Question number 301. The expression information received from a person accused of offence under section 27 of the Indian Evidence Act 1872 covers information through option A, confession statements only, option B, statements amounting to confession or admission only, option C, all forms of information whether confessional or not, option D, none of the above. Here correct answer is option C, that is all forms of information whether confessional or not is the correct answer. Question number 302. Which of the following statement is correct? Option A, confession by inducement, threat or promise flowing from person in authority giving reasonable impression to the accused that he would thereby avoid punishment is relevant. Option B, confession by accused while in custody of police even if made in the immediate presence of a magistrate shall not be proved. Option C, the confession of the accused made while in custody of the police may be proved if as a consequence of information received thereby a relevant fact is discovered, and option D, none of the above. In question number 302, correct answer is option C, that is the confession of the accused made while in custody police may be proved as if as a consequence of information received thereby a relevant fact is discovered. Question number 303. Which one of the following is not the exception to the rule of hearsay under the law of evidence? Option A, expert's opinion, option B, dying declaration, option C, confession, and option D, res gestae. Correct answer here is option C, that is confession. Question number 304. A person after committing crime confess while intoxicated the commission of crime. Under Indian Evidence Act, confession is relevant and admissible in section 29, section 30, section 31, section 32. Correct answer here is option A, that is section 29. Question number 305. Match list first with list second and select the correct answer by using the quotes given below. Here in list 1, option A is confession caused by inducement, threat, promise. Correct answer here is Pyarelal Bhargav versus State of Rajasthan. Option B, confession to a customs officer. Correct answer here is State of Punjab versus Barkat Ram. Option C, confession in the FIR given by the accused. Here correct answer is Agnu Nagesha versus State. Option C is the correct match. Option 4, that is D, discovery of a fact pursuant to a statement in police custody. Here the correct match is State of Bombay versus Kathukali-Ogad. This is the correct match here. Now by going through these matches, the correct option here is option D. D is the right answer. Question number 306. Confession of an accused is admissible against the other co-accused under section 28 of the Evidence Act, section 29 of the Evidence Act, section 30 of the Evidence Act, section 31 of the Evidence Act. Correct answer here is option C, under section 30 of the Evidence Act. Confession of an accused is admissible against under section 30 of the Evidence Act. Question number 307. The confession of an accused is only relevant against him. Which of the following section of the Indian Evidence Act 1872 is an exception to this rule? Option A, section 23, option B, section 25, option C, section 28, and option D, section 30. Correct answer here is option D, that is section 30 of the Indian Evidence Act. Question number 308. The case of Kashmira Singh versus State of Madhya Pradesh relates to privileged communications, dying declaration, confession to police officer, confession of a co-accused. Correct answer here is option D, that is confession of a co-accused. Question number 309. A and B were jointly tried for the murder of C. During the trial, A said B and I murdered C. What is the nature of this evidence against B? Option A, substantive evidence, option B, corroborative evidence, option C, hearsay evidence, and option D, direct evidence. Here correct answer is option B, that is corroborative evidence. Question number 310. In which one of the following cases Supreme Court held that confession of a co-accused are very weak evidence and no conviction can be based solely on such confession? Here options are Nathu versus State of UP, Ram Prakash versus State of Punjab, Kashmira Singh versus State of MP, and option D, none of the above. In question number 310, correct answer is option C, that is Kashmira Singh versus State of MP. Question number 311. Which is the correct proposition of law of evidence? Option A, a confessional statement made when there is a threat or inducement is irrelevant even after the removal of such threat or inducement. Option B, a confessional statement otherwise relevant is not relevant because it was made under promise of secrecy. Option C, a confessional statement otherwise relevant is not relevant because it was made when he was drunk. Option D, in case of a joint trial of several persons, when the confessional statement made by one of them affecting himself and others is proved, the court has power to consider such confession against such other persons as well as against the maker of such confession. Here correct answer is option D. Option D is the correct answer. Question number 312. The illustration that A and B are jointly tried for the murder of C. It is proved that A said B and I murdered C relates to. Correct answer is option A, that is section 30 of the Indian Evidence Act. Question number 313. Under which condition a court may take into consideration the confession of one accused against himself and another person? Option A, if they are tried jointly for the same offence. Option B, if they are tried jointly for different offences. Option C, if they are tried for the same offence but not jointly. And option D, if they are tried for different offences and not jointly. Correct answer here is option A, that is if they are tried jointly for same offence. Question number 314. A confession by accused can be used against a co-accused under section 30 of Evidence Act as hearsay evidence, only as corroborative evidence, as substantive evidence, none of the above. Correct answer is option B, that is only as corroborative evidence. Question number 315. A is on trial for the murder of C. There is evidence to show that C was murdered by A and B, and that B said A and I murdered C, as against A is against A is. This evidence is not to be taken into consideration as the evidence is hearsay, to be taken into consideration as it is direct. C, not to be taken into consideration as A and B are not being jointly tried, to be taken into consideration as A and B are accomplices. In question number 315, correct answer is option C, that is not to be taken into consideration as A and B are not being jointly tried. Question number 316. What is the evidentiary value of the confession of co-accused implicating himself as well as other non-confessing co-accused? Option A, such confession is relevant against all the co-accused. Option B, it shall not relevant against non-confessing co-accused. Option C, such a confession amounts to proof of guilt of the all co-accused. Option D, if the confession of co-accused is acquitted of the main offence, his confession shall cease to be admissible. Correct answer here is option A, that is such confession is relevant against all co-accused. Question number 317. Confession always goes against the maker of it provided it has been made freely and voluntarily. Reason: a confession is inadmissible against a co-accused. Here in question number 317, correct answer is option C, that is A is true but R is false. That is, a confession always goes against the maker of it provided it has been made freely and voluntarily is true. A confession is inadmissible against co-accused is false. Question number 318. A and B are jointly tried to the murder of C. It is proved that A said B and I murdered C. What is the nature of confession against B? Option A, substantive evidence. Option B, only corroborative evidence. Option C, hearsay evidence. And option D, none of these. Here correct answer is option B, that is only corroborative evidence. Question number 319. X and Y are jointly tried for the murder of Z. It is proved that X said Y and I murdered Z. The confession of X is option A, may be taken into consideration against Y. Option B, may not be taken into consideration against Y because confession was made by X. Option C, may be taken into consideration or not, depends upon the facts of case. And option D, none of the above is the correct propositions of law. Here correct answer is option A, that is may be taken into consideration against Y. Question number 320. In which section doctrine of dying declaration is found? Here correct answer is option C, that is section 32. Question number 321. The principle on which a dying declaration is admissible under Indian Evidence Act 1872 is indicated in the legal maxim. Correct answer is option B, that is nemo mortibus prosecutor mentiri. Question number 322. The case of Pakla Narayan Swamy versus King Emperor relates to doctrine of estoppel, accomplice, dying declaration, cross-examination. Correct answer here is option C, that is dying declaration. The case of Pakla Narayan Swamy versus King Emperor relates to dying declaration. Question number 323. The Evidence Act relates for the exception of the hearsay rule under section 17 to 39, section 32 to 33, section 34 to 35 and all of the above sections. Here correct answer is option B, that is section 32 to section 33. Question number 324. A dying declaration, statement first, cannot form the sole basis of the conviction unless corroborated, is a weak kind of evidence, stand on the same footing as any other piece of evidence, has to be subjected a very close scrutiny of the reliability. Select the correct answer by using the quotes given below. Here in question number 324, correct answer is option C, that is 3 and 4. A dying declaration stand on the same footing as any other piece of evidence. Option 4, has to be subjected a very close scrutiny for reliability. Question number 325. Proviso of section 32 subsection 1 of Evidence Act are attracted where what is not true? Option A, the cause of death is required to be ascertained. Option B, the deceased statement is related to the cause of death. Option C, the circumstances connected with the death. And option D, verbal statement is not admissible. Here in this question, it has been asked which of the following is not true. The statement D, the verbal statement is not admissible, is not true. Therefore, it will be the right answer. Question number 326. Kaushal Rao versus State of Bombay AIR 1958 is related with which topic of the law of evidence? Correct answer is option C, that is dying declaration. Question number 327. Dying declaration may be made to a doctor, magistrate, any other person, all of the above. Correct answer here is option D, that is all of the above. Question number 328. A dying declaration can form the sole basis of conviction without any corroboration by independent evidence. Option B, can form the basis of conviction only on the corroboration by independent witness. Option C, cannot form the sole basis of conviction and corroborated by the independent witness. Option D, only B and C are correct. Here correct answer is option A, that is can form the sole basis of conviction without any corroborated by independent evidence. Question number 329. Which one of the following case is directly related to section 32 subsection 1 of the Indian Evidence Act? Correct answer here is option B, that is Pakla Narayan Swamy versus King Emperor. Question number 330. To be admissible, a dying declaration must be made before to a magistrate, must be made before a police officer, must be made before a doctor, and option D, must be made to any person, a doctor, magistrate, friend or near relative is the correct answer. Question number 331. A dying declaration under section 32 of the Indian Evidence Act is admissible in evidence only when it is reduced in writing, only when it is made to a police officer, only when it is made to a judicial magistrate, only when it is made to a executive magistrate. Here correct answer is option B, only when it is made to a police officer. Question number 323. Which one of the following statement is correct? Option A, a dying declaration made under section 32 of the Indian Evidence Act 1872 is subject to the control of. Option A, section 164 of the CRPC. Option B, section 161 and 162 of the CRPC, section 52 and 54 of the Indian Evidence Act, and section 158 of the Indian Evidence Act. In question number 332, correct answer is option D, that is section 158 of the Indian Evidence Act. Question number 333. Which of the following is not a leading case on dying declaration? Correct answer here is option D, that is Deep Chand versus Rajasthan is not a leading case on dying declaration, whereas Kaushal Rao versus Bombay, Moti Singh versus State of UP, and R versus Jenkins related to dying declaration. Question number 334. In which one of the following a dying declaration is admissible? In criminal proceedings only, in civil proceedings only, both in civil and criminal proceedings, in civil proceedings only with the permission of the court? Here correct answer is option C, that is both in civil and criminal proceedings. Question number 335. For the admissibility of a dying declaration, it is not necessary that it relates to the cause of death. The person making the statement must be under the expectation of death. The person making the statement must be competent. The statement must be complete. In question number 335, correct answer is option B. Here in this question, it has been asked for the admissibility of dying declaration, it is not necessary. Option B is not necessary, that the person making the statement must be under expectation of death. Question number 336. Which one of the following is not a case of dying declaration? Here correct answer is option C, that is Sitaram versus State of UP is not a case of dying declaration, whereas Ratnam God versus State of Bihar, Paniben versus State of Gujarat, and Kaushal Rao versus State of Maharashtra is related to dying declaration. Question number 337. Which of the following could be proved as dying declaration after the death of a person? Here correct answer is option D, that is FIR lodged by the person deceased, statement of the person deceased recorded under section 161 CRPC, statement of the person deceased recorded by the executive magistrate would come into the category of dying declaration after the death of the person. Here option D will be the right answer. Question number 338. Under section 32 of Indian Evidence Act, statement of a person who is dead to be admissible, option A, must relate to the cause of his own death. Option B, may relate to the cause of someone else's death. Option C, may relate to the cause of his own death or someone else's death. And option D, both B and C are correct. Here correct answer is option A, that is must relate to the cause of his own death. Question number 339. The form of dying declaration is immaterial. Question number 340. Which of the following could be proved as dying declaration after the death of a person? FIR lodged by the person deceased, statement of the person deceased to police recorded under section 161 CRPC, statement of the person deceased recorded by the executive magistrate, all of these. Here correct answer is option D, that is all of these. Question number 341. Necessity rule regarding the admissibility of evidence is contained in. Correct answer is option B, that is section 32 of the Indian Evidence Act. Question number 342. A dying declaration is relevant evidence under section 32 of the Evidence Act, notwithstanding it being hearsay evidence because option B, if a person is dead and anything said by the person as to the cause of death is relevant, since the dead person cannot be brought before the court to testify, necessity makes it inevitable to admit the said statement. Correct answer here is option B. Question number 343. With respect to dying declaration under Indian Evidence Act 1972, choose the true statement about propositions. Propositions: percentage of burn injury alone would not determine the admissibility of the dying declaration. Absence of medical certificate as to fit state of body is a fit ground to throw the dying declaration. Third, opinion of the magistrate as to fit state of mind body would decide the reliability of the dying declaration. Here assertions are provided in the options A, B, C and D. In question number 343, correct answer is option C, that is first and third are correct and second is incorrect. First proposition is percentage of burn injury alone would not determine the admissibility of the dying declaration is correct. Opinion of magistrate as to fit state of mind body would decide the reliability of dying declaration is also correct. Whereas absence of medical certificate as to fit state of body is a fit ground to throw the dying declaration is incorrect. Question number 344. In which of the following cases a statement need not to be in writing? Option A, for contradicting a witness under section 145 of the Evidence Act, a dying declaration, a statement used to refresh the memory of a witness, a statement which can be used under section 162 of CRPC. Here in question number 344, correct answer is option B, that is a dying declaration. Question number 345. Section 32 of Evidence Act does not speak of which of the following kinds of persons? Option A, person who is dead. Option B, person who cannot be found. Option C, person who is unwilling to give evidence. Option D, person who has become incapable of giving evidence. Here correct answer is option C, that is person who is unwilling to give evidence, does not speak of the correct answer. Question number 346. A woman is raped and makes the statement that A raped her. 2 days later she commits suicide. Her statement regarding rape is admissible as dying declaration, not admissible as dying declaration, admissible as dying declaration only if there is some evidence directly connecting with her death with the incident of rape, and option D, none of the above. Here correct answer is option C, that is admissible as dying declaration only if there is some evidence directly connecting her death with the incident of rape. Question number 347. A dying declaration under section 32 of the Evidence Act is admissible in evidence. Option A, only when it is reduced in writing. Option B, even when it is made to a police officer. Option C, only when it is made to a magistrate. And option D, only when it is made in immediate presence of a doctor. Here correct answer is option B, that is even when it is made to a police officer. Question number 348. In which one among the following cases Supreme Court of India said that it is not an absolute rule of law that dying declaration must be corroborated by other evidence before it can be acted upon? Correct answer is option C, that is Kaushal Rao versus State of Bombay. Question number 349. The essential conditions for dying declaration to be relevant include the statement is made by a person as to the cause of his death, statement is made by a person as to any of the circumstances of the transaction which resulted in his death. And option C, third, person must have been under expectation of death at the time of making the statement. Which of the proposition are correct? Here correct answer is option A, that is first and second. First and second proposition is correct and third is incorrect. First and second propositions are statement is made by a person as to the cause of his death. Second, statement is made by a person as to any of the circumstances of the transaction which resulted in his death. These two propositions are correct. Therefore, option A will be the right answer. Question number 350. A dying declaration is admissible in evidence. Its admissibility is founded upon the principle of necessity. Here option A is the right answer, that is both A and R are true and R is the correct explanation of A.